Assalamualaikum warahmatullahi wabarakatuh. Welcome back to our Zoom recorded lecture. So this is part 5 for the topic contents of the contract. In part 4, we discussed about implied term, and we discussed the first two common law approach, which were terms implied by statute, and then followed by terms implied by custom or trade usage. So in this part 5, we are going to discuss on the remaining three. Okay, so the third one, number 3, terms implied by common law or by court. Meaning that here now the task is given to the court. So on occasion, the court will presume, so how the court does that? The court will presume by inferring from evidence. So, and then on what? Okay, that the parties intended to include a term which is not expressly stated in the contract. So now it's on the court to make the relevant inference based on the evidence produced by the parties. Okay, so in this situation, a court may infer an implied term, okay, from evidence. And from this evidence, the court infer that the parties must have intended to have it included in the contract, even though it's not expressly stated in that particular contract. So from the evidence, circumstances, whatever evidence produced in the court, so there will be relevant inference. So that's why it falls under terms implied by court or by common law. Okay, and how does the court do that actually? How to make the relevant inference here? So how, or another question or queries here, how to infer, okay, the intention of the parties, because intention is something which is subtle in the minds of, on the minds of the parties. How the court does that? How does the court do that? Okay, so actually the court has formulated two tests. Okay, so in order to make relevant inference, okay, to ascertain the intention of the parties, there are two relevant tests here. They are, the first one, the officious bystander test, and another one, the business efficacy test. So, so of course we cannot find these two tests in the contractual, in the statutory provision, but these two tests are creation of case law. So it is formulated by way of decided cases, case law. Okay, let's have a look at the common law case. This is decision by federal court. The case is Sabah Bumi Sandakan Tuan Berhad and Datuk Yap Pak Leong, reported in year 1998. The decision was delivered by Pe Swin Chin, federal court judge. So it was clearly stated in this case as part of the judgment decision here. Implied terms are of three types. See, the first are those which the court infers from the evidence that the parties to a contract must have intended to include in the contract, though not especially set out therein. So this is the one that we are discussing. Here, altogether there are three. Okay, based on this case, the court made it clear. The court made it clear there are three types or three categories, even though for our discussion we have more, okay, based on approach at common law. But from this case specifically, there are three, at least three. So the first one are the one that we're discussing, okay, the court's role to infer, okay, based on the evidence, based on the evidence. Okay, and then in so how, for the first category just now, the inference by the court here. So the court said, the court further stated here, the judge further stated here, there are two tests, okay, must be satisfied, okay, before a court could infer, okay, the implied term here. Okay, the first one is subjective in nature. This is the officious one, officious bystander test. So what does it mean here? Something so obvious, okay, that it goes without saying, so that if, while the parties were making their bargain negotiation, so if we were to invite, okay, were to ask officious bystander, okay, were to suggest some express provision, okay, for it in the agreement. So if we were to ask bystander, they would tacitly suppress him with a comment, oh, of course. So it's very officious, okay, officious bystander test. It should be a term impliedly, even though it's not expressly stated. And then the second test is that the implied term should be of a kind that will give business efficacy to the transaction of the contract of the parties here. So it means that the desired result of the business in question. So it gives efficacy to the transaction. Okay, when the court applied this test to the facts of Sababumi case here, the court said that there is no doubt that by the 1987 agreement, the relevant agreement in that particular case, both parties actually had decided to commit to each other in regard to such a business on long-term basis, apparently for 20 years, even though it wasn't stated in their contract. But then if you were to apply all these tests, the answer will be yes. Mean that here, yes, impliedly, they had agreed, decided to commit to this business long-term basis up to 20 years. Okay, and again, this is part of the application. Okay, the court applied the officious bystander test here. So at the time of negotiating for the said agreement, if an officious bystander had asked the question whether such exclusive right, that's the right, such exclusive right, implied term, to operate off course and on course betting, it's about betting business here, for 20 years would continue if the licenses and the said assumption were issued or granted by any other laws or by law other than the state gaming ordinance. So both parties would have answered yes, of course. I mean, yeah, if they have the right, all the relevant licenses whatsoever, I mean, it's a long-term arrangement between them, even though it wasn't stated clearly. That's why the term should be there by way of implied, implied term here. And then the answer to the official bystander will give business efficacy. So they are relevant. I mean, the more usually once the official bystander test is satisfied, and then whether it will give business efficacy, usually the answer will be yes, it will give business efficacy to the said business. So 20 years long-term commitment will give business efficacy to this betting related businesses. So we are done with the third one, terms implied by common law or by court. All right, and the fourth one, terms implied by a law, specific law, especially example here, contract of employment, because in each contract of employment, there is implied term that employer will not, this is on the part of the employer, obligation of the employer, will not without reasonable and proper cause conduct itself in a manner calculated or likely to destroy or seriously damage the relationship of confidence and trust between employer and employee. I mean, here there is trust and confidence between employer and employee, even though it's not clearly stated in the contract of employment. Impliedly, it has to be there. And where the breach of the implied term results in financial loss to the employee, resulting from loss of reputation, so employee here can recover damages, compensation for their pecuniary losses which flow from the breach of the implied term. Even though if we were to examine the contract of employment, there's no express term saying that employer would conduct the business honestly, and then would affect reputation of the employer whatsoever. But impliedly, it has to be there. Because why? The nature of relationship between employer and employer, there must be trust and confidence between them. So this is the decision by House of Law in the case of Malay and Bank of Credit and Commerce International SA in compulsory liquidation, as well as, both cases were heard together. Mahmud and same respondent. So Malay and then another party is Mahmud and Bank of Credit as well. Okay, and from these cases, this is House of Law observation. The parties were agreed that the contracts of employment of these two former employers each contain an implied term to the effect that the bank will not, because their employer was the bank, without reasonable and proper cause conduct itself in a manner, and the bank was under an implied obligation. It's not expressed an implied obligation to its employee not to conduct a dishonest or corrupt business. So of course, business has to be legal, has to be honest, even though it's not stated in their contract of employment. Okay, number 5, the fifth one, terms implied or imported from previous dealings between the parties. So it's like 4 plus 1, because here it depends on whether there was any previous dealing. Sometimes there's no previous dealing, so that's why we can apply number 5. So if there was previous dealing, there were previous dealings between the parties, then yes, you can imply the relevant term based on their previous dealing, past dealing between them. So the court may infer terms from a previous course of dealings between the parties. For example, the case of Popular Industries Limited and Eastern Garment Manufacturing, Sunam Berhad, 1989. This is our local case. So let's go to the facts. Actually, you're going to discuss this case again in your contract 2 later when you discuss damages. Okay. So the plaintiff in Canada, the company actually, okay, they ordered certain goods from defendants. Defendants were, I mean, the location were in Penang, Malaysia. And the goods were to be delivered between the months of January and June 1980. And plaintiff argued that defendant knew, okay, that plaintiff bought the goods for resale. Meaning that here we are buying the goods for the purpose of reselling it, okay, at a profit. And if there is any breach, okay, later there was a breach of the contract and defendant, okay, the one who is supposed to supply the goods, okay, failed to deliver the goods to plaintiff in Canada. So, and then defendant argued that there was no concluded contract, okay, and then alternative argument, even if there were concluded contract, defendant were discharged by reason of failure of the plaintiff to provide any letter of credit. Meaning, yeah, defendant said, no, we are not in breach because why you failed to give us letter of credit. Meaning, the payment, okay, the mode of payment, letter of credit to prove that we are going to pay you on credit. The transaction is done on credit. But the court held that defendant were liable for damages for breach of contract. There was breach of contract because of failure to deliver, okay? Because why? Nowhere in the contract was there any provision, okay, that the existence of the contract depended on the opening of the credit by plaintiff. In the contractual term, okay, there's nothing mentioning that, oh, the contract is dependent. It depends on whether there's any letter of credit or not. So the parties had not agreed either expressly or impliedly, and there's no implied term lah here. So this is the case in which it says there's no implied term. Okay, to the effect that their previous course of dealing confirmed that. So they had previous dealing before, and I mean, it's not compulsory, it's not necessary, it doesn't necessitate that there must be letter of credit between them, okay? And the defense that there was no concluded contract because no letters of credit had been opened 60 days before shipment was therefore clearly unsustainable. So the court rejected the argument, meaning that here the contract still subsists even though without the letter of credit here. It's just describing the mode of payment, okay? Okay, another subtopic. Okay, we are done with implied term. Okay, express term, we covered condition, warranty, indefinite terms, and then we proceeded with implied term. Now another, just a small subtopic. I'm not going into detail, just to introduce you to the term, so that when you come across, you have some basic idea of this. Okay, collateral contracts. Okay, it reminds me of one old movie. Okay. The title is collateral damage, right? So here, collateral contract. So what is collateral contract? So we have the rule, okay, the principle of law here. So the doctrine of collateral contract, it enables pre-contractual statements, okay, to be admitted as, to be admitted, to be recognized as a separate contract, and it stands as collateral to the main agreement. I mean, here it stands side by side. So, and this is the quotation from the case law. A collateral contract, by its very nature, it exists side by side with the main contract. It's collateral. It's not the main one, but it exists side by side. It does not have the effects of substituting the main contract because it's just collateral in nature. So a collateral contract merely confers certain other rights which are not incorporated in the main contract. So that's the function, okay, of the collateral contract. It doesn't substitute, it doesn't replace, okay? Main contract must be there, okay? But it just gives some other rights, okay, which are not incorporated in the main principal contract. So we have the case here, 1993. The case is Industrial and Agricultural Distribution Sdn Bhd and Golden Sands Construction Sdn Bhd. Plaintiffs to defendant for breach of contract. It is pertaining to sale of 2 new units of excavators sold by plaintiff to defendant. So it involves certain sale and purchase of 2 units of excavators. And then now the claim is, the action was brought, the claim is for the loss of the depreciated value of the 2 excavators, because which were recovered by plaintiff from defendant after defendant repudiated the sale contract. Here there was termination of contract, so now plaintiff recovered, okay, the units lah, okay, is it the vehicle, okay, here. And then defendant here, okay, when they return, okay, the excavator, defendant was acting under an oral or a collateral contract, meaning here it's not something in writing, given by plaintiff, okay, to the effect that if defendant found the excavators delivered to it to be unsuitable, defendant could return them to plaintiff without incurring any financial obligation. Meaning, okay, if it's not suitable, you can return it to us. But here, this is just oral warranty, oral collateral warranty. And defendant requested plaintiff to take the excavators back. Okay, take back. We don't want. Okay. And then we are not paying you anything, okay, without having to pay plaintiff any sum of money. So this is actually the argument by defendant. Defendant was saying that, well, we are returning the excavators because you give us this collateral warranty orally. It's not something in writing. So the court could not really examine, okay, whether such warranty exists or not. So now, what's the issues in the court? The issues before the court. So the two issues here, okay, there were two issues here. Whether the defendant has established that the plaintiff did make, okay, whether such an oral collateral warranty really existed or not. And number two, whether, let's say if it is yes, okay, whether the defendant was justified. Meaning if the answer is yes for the number one, so whether the defendant was justified in returning the excavators and to refuse to pay the purchase price. Return and no payment at all. Okay, is it justified or not if the existence of collateral warranty is accepted by the court? So this is the court's observation. The court said, okay, first we look at the main contract. What's the main contract here? So the main contract in this case is for the sale and purchase of the two excavators. And what is the collateral contract here? The collateral contract is the existence, okay, meaning here the one who alleged this collateral contract is defendant, okay. Defendant said if the parties agreed, if the excavators were found unsuitable by defendant could return them without any financial obligations. So, but again, from the evidence, okay, there was no sufficient evidence at this by defendant, okay, to satisfy the court. I mean that here, the court cannot simply agree or admit, oh, there was such oral collateral contract here. And then this is also observation from the court. Okay, yes, there is clearly an agreement between the parties for the sale and purchase. I mean that here, the main agreement, sale and purchase of the two excavators. And the court said, if defendant's contention is accepted, okay, the effect of the alleged collateral contract, which is not proven actually, okay, actually is to obliterate or to destroy the main contract or sale. Meaning that here, if you are not paying anything for it, as if there's no purpose of entering into sale and purchase agreement here, okay. So, and the court said there cannot be a collateral contract without the main contract being in existence. Meaning that collateral would diminish, will destroy the existence of main agreement. If it was proven, but it wasn't proved actually. So, and the court said, if defendant is allowed to return the excavators without incurring any financial obligation to plaintiff, so the main contract, so the sale and purchase of two excavators becomes meaningless because defendant is no longer under any obligation to buy the excavators under the main contract. So remember, collateral is like the supplementary subsidiary to the main one. Okay, so it has to exist side by side. If the main one is no longer in existence, so there's no collateral contract at all. Okay, that's what the court said. Okay. And then in relation to assumption clause, we haven't come to that particular part yet. Okay, we are going to discuss a little bit longer on the assumption clause. So in relation to principle, collateral contract rule. Okay, here the rule of collateral contract. Collateral contract overrides the assumption clause. Okay, I mean here, yes, it's possible for the assumption clause to be overridden by the collateral contract. This is the case of J. Evans and Sons and Andrea Merzario, 1976. This is common law, the judgment by Court of Appeal. So in this case, the court held that, we zoom to the decision, okay? The court held that the oral promise, okay, was contractual, okay, and enforceable, is valid basically. So it overrides printed assumptions from liability. So usually assumption from liability in the form of assumption clause is printed. So it prevails, okay, over this assumption, okay, because assumption is meant to exempt liability, okay, from the wrongdoer, the one who breached the contract. And this is some of the cases for further reading. It's a long list of cases. if the case is in their textbook, you can have a look. If it's not, then you can try to read from Lexis Nexis. Okay, we have the case of Tan Chong and Sons Motor, Tan Kian Tong, that was Supreme Court. Padang Serai, Kilang Kayu, okay, Keluang Wood Products. So all the cases here, some I indicate can Supreme Court, High Court, but the other two, you have to check whether is it from High Court or is it Superior Courts. Okay, we stop here. We're going to continue in part 6 of our lecture. So I stop share. Okay, Assalamualaikum warahmatullahi wabarakatuh.